Good evening, all. Welcome to the Williston Development Review Board. Tonight is October 22nd, 2024. My name is Pete Kelly. I'm chair of the DRB. Please silence your phones and devices. Zoom attendees, please stay muted unless it's your turn to speak. For Zoom technical questions, contact planning staff through Zoom chat. I'll begin by taking a roll call of DRB members in attendance this evening. Nate Andrews.
Here.
Paul Christensen is absent. Lisa Braden-Harder is absent. Scott Riley.
Here.
Dave Turner.
Here.
Chair is present. There are 4 in attendance. We do have a quorum. The Development Review Board follows rules of procedure and conducts quasi-judicial proceedings, aka public hearings like court, pursuant to Williston Unified Development Bylaw, WDB, Chapter 6 and Appendix A. The powers of the DRB are established in and limited by this bylaw, as well as state statute, and expounded upon in the staff reports for each public hearing application. As volunteer public officials, we are held to the standards of the Williston Volunteer Policy and the Williston Conflict of Interest Ordinance. For any public hearing item tonight, first question to the DRB members, does any member wish to be excused on account of a conflict of interest? Hearing none. Second question, does any member wish to report any ex parte contact?
No.
Okay. Tonight's agenda. First order of business is the public forum. This is an opportunity for members of the public here present and for those participating remotely by Zoom to address the board on anything that is not on tonight's agenda. Any raised hands? No?
No.
Okay, next up is the public hearing. First up is DP 22-06.1, Green State Realty, LLC. I'm going to open the hearing at 7:02 and immediately continue it to November 12th, 2024, without testimony. Next up is Appeal 25-01. This is an appeal of a zoning notice of violation issued July 24th, 2024. It relates to AP 23-0121, an administrative permit issued for dog rescue home business at 170 Lamplight Lane in the residential zoning district. Who is present here from the appellant? Would you please come forward? Good evening and welcome. If you would state your name and address for the record, please.
Good evening. My name's Christian Shorba. I'm an attorney at Downs, Racklin, Martin. We're at 199 Main Street in Burlington, Vermont.
Thank you.
And I'm here with the appellant, Ms. Pederzani.
Donna Pederzani, 170 Lamplight Lane, Williston.
Okay, welcome. Staff goes next. Melinda.
Thank you. So this is an appeal of the zoning administrator's issuance of a notice of zoning violation in regard to the unpermitted operation of a dog rescue home business, the Vermont English Bulldog Rescue, at 170 Lamplight Lane in the residential zoning district. Per WDB 5.4 and as provided by 24 VSA 4465, any decision of the administrator may be appealed to the DRB. The DRB must hold a public hearing. Following the hearing, the DRB may uphold, modify, or overturn the decision of the administrator. In every case, the DRB shall adopt written findings and conclusions supporting its action. The DRB decision on an appeal can be appealed to the Vermont Environmental Court, as provided by 24 VSA 4471. I'm going to first go over the history of violations, applications, permits, and decisions leading up to this appeal, starting with the notice of zoning violations. So the original notice of zoning violation was issued on September 16th, 2022. This was for the operation of a dog rescue without a permit. The second was May 14th, 2024, over a year after the original zoning violation was issued. The zoning administrator issued a warning of a zoning violation to the appellant for continued dog rescue operations without a valid permit. And on July 24th, 2024, the zoning administrator issued a notice of zoning violation to Ms. Pederzani for continued dog rescue operations without a valid permit. Ms. Pederzani appealed the July 24th notice of zoning violation to the DRB. The appeal hearing was scheduled for September 24th, but continued to October 22nd today, and no testimony was taken at the previous DRB meeting. So tonight, the DRB hearing will be hearing this appeal. On September 22nd, 2022, a permit application was submitted by Ms. Pederzani to establish a dog rescue home business. This was in response to the notice of zoning violation previously issued. The zoning administrator subsequently referred this permit application to the DRB. The DRB held a public hearing on November 8th, 2022. The DRB deliberated on November 22nd, 2022, and issued a decision denying the administrative permit for a dog rescue home business. On January 13th of 2023, this denial was appealed to Vermont Environmental Court by Ms. Pederzani. On February 1st, 2023, the appeal of AP 23-0062 was withdrawn by Ms. Pederzani. So the current status of AP 23-0062, the original administrative permit for this dog rescue, is that it's denied permanently. It cannot be appealed. On January 6, 2023, a permit application was submitted by Ms. Pederzani to operate a scaled-down dog rescue home business. On January 20th of 2023, the permit was approved by the zoning administrator with a letter enumerating findings of fact, conclusions of law, and conditions of approval for the permit. On February 2nd, 2023, the permit, the issuance of this permit was appealed by Mark Hall, Esquire, on behalf of appellants Kim Butterfield and Ron Bliss. They filed an appeal of AP 23-0121 to the DRB. On March 14th, 2023, the DRB overturned the zoning administrator's issuance of AP 23-0121 and denied a permit for the dog rescue home business. On April 13th, 2023, Ms. Pederzani appealed the denial of AP 23-0121 to the Vermont Environmental Court. On January 31st, 2024, the denial of this permit was upheld by Vermont's Environmental Court. They issued a decision upholding the DRB's decision of March 14th, 2023, and denying a permit for the for the dog rescue home business. On March 6, 2024, Ms. Pederzani filed an appeal of the Environmental Division's decision to Vermont Superior Court, and that decision is pending. So the current status is basically there's the AP 23-0121 is neither approved nor denied. It's pending Vermont Superior Court decision. Following numerous complaints, the zoning administrator issued a notice of zoning violation on July 24th, 2024, following a warning letter on May 14th, 2024. And, as I said, prior to the current notice of zoning violation, the zoning administrator had received numerous complaints and a letter requesting the town enforce the previous zoning violation dated September 16th, 2022. The appellant is appealing the decision of the administrator to issue this zoning violation because they believe the right to operate the dog rescue is vested upon the zoning administrator's issuance of AP 230121, which the DRB overturned and is currently undergoing an appeal at Vermont Superior Court. The appellant argues that until the current appeal is resolved, the permit should be considered valid and no enforcement should be pursued. So we have received a number of comment letters, and they were provided in the DRB packet and are available on the website. A legal opinion was obtained as part of this review, and I will be referring to it in discussion that follows. So the town attorney has advised us that the appellant had a right to, when she filed this appeal to the Vermont Supreme Court environmental decision, to request a stay of the DRB's decision. That was the decision that was being appealed. And the appellant could have requested a stay of that decision, which is essentially a freezing of that decision or a requirement that no further enforcement be done until a decision is issued by the higher courts. And so that, because the appellant didn't seek a stay of the DRB's decision, and none was issued from the Environmental Division, nor was one sought from the Vermont Supreme Court, the DRB's decision stands, and she lacks approval to operate the home business during the pendency of the appeal, which is why the zoning administrator issued the notice of zoning violation. The residential zoning district doesn't allow commercial uses, and a dog rescue is only allowed as a home business. WDB 20.4.3 requires a permit for a home business. And furthermore, WDB 5.3 states that permits do not take effect until after the appeal period has expired. So the administrator's decision to issue a permit for the dog rescue was appealed to the DRB. The DRB overturned the zoning administrator's decision and denied the permit. The DRB's decision was appealed to the Vermont Environmental Court. The Environmental Court's decision upholding the DRB's denial is now under appeal at Vermont Supreme Court. Because no stay was issued by either the Environmental Court or the Supreme Court, the DRB's decision stands and there's no valid permit for the dog rescue business. Lacking a permit to operate this home business is a violation of the town's bylaw. The town's attorney has advised that the town is required to cite violations through the warning letter and NOV process when they occur or are reported, especially in a written complaint. Because it's been over 1 year since the initial notice of zoning violation dated September 16th, 2022 was issued, the town was advised to issue a second warning and notice of zoning violation. This NOV constitutes the action the town is taking currently to correct the violation. It has been the town's practice not to take additional enforcement actions until the appeal period has run its course. So the DRB decision tonight is really focused on the following issues. One, does the appellant have a valid permit to operate the dog rescue home business? And two, did the zoning administrator properly issue a notice of zoning violation? So I've included 3 options for the DRB, either to uphold the zoning administrator's decision, to modify the zoning administrator's decision, or to overturn the zoning administrator's decision. Thank you.
Thank you. DRB members, any questions for Melinda before we turn it over to the appellant?
Nope.
Okay.
Nope.
It's your forum.
Great, thank you. Thank you for having us here. So I'd like to make just a few points tonight. I'd like to give an overview of those points and then maybe go deeper into them as we get into this hearing. The first point I'd like to make is that what's occurring before the Supreme Court, which, by the way, we have oral argument on Thursday, 2 days from now. So that case is fully briefed. We will be arguing it in 2 days, so we're essentially on the eve of that final hearing, and we will presumably be getting a decision within a few months. I would say typically, 4 to 8 months, something along those lines. Of course, we don't know exactly how long it'll take, but the absolute final piece for us as parties is about to take place. That will represent the final step in the notice of zoning violation that started all the way back in September of 2022. So, as was just discussed, Ms. Pederzani received that zoning violation all the way back in September of 2022. To cure it, she sought an administrative permit. That permit was initially, initially she was not able to get a permit via that route. However, she submitted an application for a scaled back permit, which was granted by the zoning administrator, and our argument is that it was correctly granted. She is operating, or I should say she was at that time, operating a kennel, which is allowed under the town of Williston's zoning bylaws. It is clearly carved out and allowed as an exception to the general prohibition on so-called outdoor workspaces. So she validly received that permit. This DRB then reversed that. She appealed to the environmental division, which upheld the reversal, we believe incorrectly. Again, we believe the zoning administrator was correct in his initial determination, and now we are before the Supreme Court, I should say. There is a typo here in this staff report saying that it's pending before the Superior Court. It is before the Supreme Court. We believe that the Supreme Court will determine that our position is correct and that the zoning administrator validly issued that permit, that his reasoning and our reasoning is correct. But I'll get into that in a little bit, but the point is that that is an ongoing process that represents the final piece of that initial zoning violation. So it was incorrect to issue a subsequent zoning violation in July of this year, and it goes against town practice. As was just discussed, and I'll just read from the staff report, it has been the town's practice to not take additional enforcement actions until the appeal process has run its course. So obviously we talked about, well, maybe we should have applied for a stay before the environmental division or before the Supreme Court, but there is this statute cited by the town attorney doesn't stand for the proposition that you can apply for a stay of a reversal of a permit. 24 VSA 4449 clearly talks about staying actual permits, not reversals of permits. The language is, if an appeal is taken to the environmental division, the permit shall not take effect until the environmental division rules in accordance with 10 VSA 8504 on whether to issue a stay, or until the expiration of 15 days, whichever comes first. So this statute by its plain language has no applicability to our situation. This statute would apply if Ms. Pederzani received a permit and then the neighbors from the DRB and the neighbors appealed that. This provision would say that that permit that Ms. Pederzani would hypothetically have received shall not take effect, right? Not a reversal of the permit shall not take effect. So this statute has no applicability to our situation. And I would say that sort of supporting the fact that it has no applicability, I'm looking at a letter from Attorney Mark Hall to Matt Boulanger, dated September 17th, 2024, which I think should be in your packet. And he primarily cites to this idea that he primarily cites to section 4452 of Title 24, not to 4449. And he says that, well, That statute that he cites to, 4452, says that there are repeated themes of cannot, shall be fined, and shall institute. Again, that process of cannot, shall be fined, and shall institute, that's already occurring before the Supreme Court, and we have a hearing on it in 2 days. Conspicuously, Attorney Hall does not actually cite to any of the language of 4449 because, again, that language does not apply. So that's my first point, is that this process, dating back all the way to September of 2022, is still ongoing. The second point is that, in a sense, all of this has mooted out. Ms. Pederzani has moved her operations to Merchants Row. So I think in my letter, certainly I cited to that. She now is running her dog, Vermont English Bulldog Rescue, out of 115 Merchants Row. It is fully furnished. It has all of the equipment, all of the supplies for these dogs. None of that is located in her home anymore. That wasn't the case over the summer. There still were some supplies being held at her home, but now all of these supplies are at the 115 Merchants Row building. It is the move is 100% complete, as of at least several weeks ago. I think predating even the hearing that was supposed to take place in September. So that is a situation that has changed since the issuance of this second NOV, which again, we believe never should have been issued. Dogs are now exclusively adopted at the Merchants Row building. And they are exclusively held at the Merchants Row building. I think that, certainly while she has been doing adoption events at that Merchants Row building for over a year, because it wasn't fully furnished, fully equipped, et cetera, on some adoption days, and there's an average of one per month, one adoption per day, one adoption per month, and those occur on Saturdays. Sometimes people who were anticipating adopting dogs would not show up, or they would show up and they would feel that the dog was not a fit, or perhaps the dog was sick and couldn't be adopted on that particular day. In some of those situations, Ms. Pederzani would take that dog and foster it at her home temporarily and wait for the adopters to be able to show up. Now that everything is in the Merchants Row building, she is no longer doing that. The dogs can stay overnight in the Merchants Row building, and that's what they are doing. That building is now, by the way, fully permitted. Ms. Pederzani has a permit to operate the adoption nonprofit out of that building. So that is, again, something that has changed since the issuance of this second NOV, which, again, should not have been issued. So, again, it's fully mooted. It's fully moot at this point. We do not believe that the town should go forward with any further enforcement action. We believe it should stick with its prior and well-established practice, again, to not take additional enforcement actions until the appeal process has run its course. Just a few more notes. I guess I could emphasize a point I made earlier, which is that Ms. Pederzani is in fact entitled to a home business permit. I'd be happy to go into that analysis. Like I mentioned before, we believe that the zoning administrator was correct from the get-go. There is an exception in the zoning bylaws for kennels. Kennels can be for commercial purposes, including boarding and breeding, and may be permitted as a home business. That's clearly laid out in Chapter 20, Section 4. Chapter 20, Section 4 in Appendix G. That's laid out in the definition section, 20.9, kennels. Kennels used for commercial purposes, including boarding and breeding, may be permitted as a home business. In other parts of the zoning bylaws, it's noted that kennels can exceed the typical height limits for fences on residential properties. And so this implies that kennels can be not just indoors, but outdoors. So privacy enclosures, for example, around an outdoor spa, and the fencing of kennels may exceed the height limit established in WDB 20.8.2.1. And that is in Williston Development Bylaw, section 20.8.2.3. So again, kennels are a clear exception to the general prohibition on outdoor workspaces, and clearly kennels are in fact contemplated as being outdoors. In fact, kennels are the only specifically enumerated type of home business in the development bylaws, period. And I should say that the general prohibition of the propositions of Chapter 20, Section 4, and Appendix G, and the specific exception for kennels contained in Chapter 20, Section 9, what I should say is that there's a general prohibition on outdoor workspaces in Chapter 20, Section 4, and in Appendix G. However, there is a specific exception in Chapter 20, Section 9, and that specific exception not only is narrower, but it is detailed later in the zoning bylaws, implying that it is, in fact, an exception to the earlier stated, more general proposition. Another point I'd like to emphasize, which I think I already kind of stated, is that Ms. Pederzani has drastically reduced the frequency and intensity of her activities at her home. In fact, there's nothing going on there anymore. I think, when this second zoning violation was issued, there were still just a few things, such as fostering dogs over the weekend, dogs that had not been picked up on a particular Saturday, dogs that were sick. Again, that is now fully done at the 115 Merchants Row building. And then the final point, and I know that Attorney Hall will probably address this, is that, in fact, that fostering of dogs that she was still doing over the summer was, in fact, dog fostering. It was no different than anybody else fostering a dog at his or her home. Yes, Ms. Pederzani runs a dog adoption nonprofit, but those dogs that she was holding at her home, she was doing in the same way that anybody else associated with the nonprofit, or not even really associated with the nonprofit, could be doing validly in their own home. Ms. Pederzani could have arranged for those dogs to be fostered at other homes, but she wanted the flexibility to foster them at her home. I think there would be no dispute that if a volunteer took one of those unadopted dogs to their home in Williston, in the same neighborhood, there would be no enforcement action against them. So Ms. Pederzani simply did not want to be singled out as the only person who is not allowed to temporarily foster dogs for a few days. So that's where we are now. Again, we think that we'll win on the merits before the Supreme Court. I've laid out that that there is this specific exception. It is an exception to the more general proposition that outdoor workspaces are not allowed. And this is a moot point. Everything has been moved, and we should stay consistent with prior town practice, which is not to institute another zoning violation, another zoning action until the appeal process has run its course. So I'd be happy to answer any questions, or for more specific details, Ms. Pederzani could testify to those.
Okay, thank you. DRB members, questions for the appellant?
At what point was everything moved over to the new location, and were you still having some volunteers come to your home location?
So I think that depends what you mean by everything. All of our transports have been done at the Merchants Row building for about 18 months. So no transports to my home ever. All of the adoptions were moved off-site at least 12 months ago. So they were done at Pet Food Warehouse, they were done at PetSmart, they were done at the Merchants Row building, various sites away from my home. No adoptions at my home at all. What I did was fostered dogs and cared for them at my home. So it was done sequentially, I guess. Total movement off-site, July 1.
Okay. So no volunteers went to your house while you had dog there
No
fostering too?
volunteers at my house. There is an empty garage. All of the outdoor kennels were sold off probably 6 to 8 months ago. There are 3 kennels remaining in the backyard. Those were kennels that I purchased for my own dogs. I'm not even using them, but I just haven't sold them yet. All of the kennels that belong to the rescue are either at the Merchants Row building, or the ones that were outdoors were sold off.
Thank you.
Could I just make another point? You know, I haven't received any communications from Attorney Hall, certainly in the past month or so. So the situation has really, the tension between the parties has really, as far as I can tell, died down considerably. With that said, Ms. Pederzani and I did discuss this, you know, have there been any other situations involving your neighbors in the past month or so? And she did outline a situation where she had, the father of her daughter was visiting.
I'm gonna object to this, this has nothing to do with the zoning appeal.
We're
I
simply,
mean, I don't wanna just get into it, devolve into who did what on first, it has nothing to do with this.
Yeah, this is, I'm gonna let him continue. This is not a court, but please truncate
sure,
it. Thank
yeah,
you.
yeah, point is, it's really very much chilled. The only situation that Ms. Pederzani outlined to me was that the father of her daughter visited, and she can clarify this, because she certainly has the details, visited a few weeks, last week or a week ago. And this is sort of consistent with our position, is that a lot of visits to her home have been misinterpreted as potential adopters. She has many people who come to her home to visit with her, to visit her daughter, to visit her son. And in this case, it was the father of her daughter was visiting with his own 2 dogs and was photographed by a neighbor who presumably was assuming that this was a dog adopter. So again, that's been a common theme through this whole thing, is that she has people coming to her home who have no relation to the dog adoption nonprofit, and the neighbors are assuming that they must have a connection.
Okay. DRP members, other questions?
Sure.
Nate, go ahead.
Welcome back, Donna.
Thank you.
I do think it seems that you've made a pretty good effort to move an operation that is a large operation away from your home. That's clear. I do have a couple questions just to refresh myself around like the scale of all of it. How many dogs per year are you adopting out now?
Currently, somewhere between, I would say right around 600 per year.
Okay. And what year, we have 2 years of history here, but what year did you start adopting dogs?
1998.
So it has grown considerably, so what was not a problem in the beginning, maybe turned into one, and again, you seem to have moved most of it out. Is there a lease for Merchants Row?
Yeah, the lease is in progress.
It's in progress.
The lease, that's a good question. The lease is in progress. It would be with Jeff Davis. He has given her full permission to use that space. And our understanding is that his son may be locating a business in the same building, and they're sharing space. They've sorted out the HVAC system to accommodate both of them. I've been in touch with Jeff Davis. Ms. Pederzani has, and we're just waiting on that final lease, which, a signed lease, but he says that I believe it's the indefinite future, she is fully allowed to be there, and so we've been in constant communication with him. Again, we have a permit.
So will that be, or is that staffed full-time, or when there are dogs staying there?
So this nonprofit has always been volunteer only. So when you say staffed, we don't have any paid staff, but we have a core of volunteers that are there first thing in the morning. We have a core of volunteers that are there in the afternoon. And we have volunteers that come to the building that have access to it throughout the day to take dogs on field trips, to take dogs for walks, to take a dog home for a few days. So if that constitutes staff, I would say it is.
So I would just ask that we really not dive into operations off-site. That it's not relevant to why we're here tonight.
Okay. In the permit that we are discussing tonight, the application was for a scaled down dog rescue, not a kennel. Is that correct? So,
It is a dog rescue, but it is by its very nature a kennel. So a kennel.
So it was for a scaled down dog rescue was how it was submitted. And the reason I'm asking questions about staffing, et cetera, is a particular place leased, is because I'm trying to get a sense of, is it even possible to move what is in Vermont bigger? You were recently quoted as 700 dogs a year. Tonight you said 600, but it is a significant amount. And I'm trying to get a sense of, is it even possible to move, that this has been moved over there? But I don't need to ask anything.
Oh, okay. Oh, do you have other questions?
Nope.
Okay, thank you. Scott?
All set.
Okay, at this point, I'm going to ask members of the audience here in person or participating by Zoom to address the DRB, please. If you have comments or would like to address us, please come up to the public table here and state your name and address for the record, please.
I'm sorry, could we just clarify, I'm just asking Ms. Pederzani if she could clarify the exact number of dogs, if there was a discrepancy between the BT Digger article and the number she just quoted. Do you want to elaborate on that?
I do. And I think when you said, is it even feasible to move that? If you're thinking about 600 or 700 dogs as a mass of dogs being moved somewhere, that's overwhelming. We bring in dogs once a month by transport, and for instance, our transport last weekend was, I think, 35 dogs. It could have been 60 dogs, but that number is always in flux. If dogs are scheduled to transport, they get sick, they need surgery, something happens, that number changes. So we typically do not bring more than 60 dogs at a time once a month. And that is why that number is 600 to 700. But it's not a lump sum of dogs that are brought up and housed. We would rarely have more than 10 to 12 dogs at any given time that we're holding, waiting for adoptions. Does that make sense?
Yeah, no, that totally makes sense. Yep, yep. Okay. Welcome. State your name and address for the record, please.
My name is Mark Hall. I'm attorney at Paul Frank Collins. We're on Church Street, Burlington, Vermont. I represent a group of neighbors represented by Mr. Bliss and Ms. Butterfield and Ms. Randall next door to me. And I'm representing them from the original appeal of the permit we're talking about today. I don't have much to say to the circumstances. There is information in your packet relative to the original notices of complaints of violations that were made by various neighbors. It contains narratives and dates and photographs of people who we know the volunteers for the program and have been assisting Ms. Pederzani in business in the neighborhood. whether or not she can operate under some sort of vested rights principle in the original permit that was vacated by this DRB and vacated again by the Environmental Court, is now pending before the Vermont Supreme Court. I agree 100% with the town attorney. I submitted a letter to the DRB expressing my opinion of it, apart from before I saw the town's opinion, that the DRB's decision vacating the permit is valid and remains in place unless a stay is issued by the Environmental Court to freeze that decision. Once the Environmental Court makes a decision regarding the vacating of the permit again, that decision stands unless the Supreme Court issues a stay. No stay has ever been sought of this court's determination vacating the permit. No stay has ever been sought vacating to stay the Environmental Court's vacating of the permit. I think part of the reason why no stay has ever been sought is because they would lose on the merits of the stay, because you have to show that you would have a likelihood of success on the merits relative to the decision in question, and they just can't make that case in front of the court. Now, we are currently.
Well, you are speculating on why somebody else is not doing something. So don't do that,
I would
please.
say that there is a standard that they would have to meet, both before the Environmental Court and both before the Supreme Court, and no attempt was made to do so. That I can say.
Okay.
Now, we are arguing the case on Thursday at Rutland High School, of all places, before the Supreme Court, and we're going to be hearing, the court's going to be hearing all the very same arguments that were made here about kennels and exceptions and so forth, which were already rejected by the Environmental Court, and were never really made to this board originally. So this is really not the place to be arguing about a decision that's already been rendered by the Environmental Court and is currently pending before the Supreme Court. The sole issue here is whether or not the permit that you vacated stays vacated until such time as it either gets overruled or there's a new application filed for a home business in this location, at which point we can take up all of these issues that were raised tonight in that context. Now, if, for example, the business moves off-site, stays off-site, that's a whole different ballgame. The neighbors have only been concerned with this whole process is activities occurring outside the home. If there are not going to be this litany of dogs coming through the neighborhood, sometimes as many as 9 or 11 in the past, and with volunteers coming in at various hours, that stops occurring. Our concerns are remedied. So, I mean, we're sitting in a situation, if this is going to be made moot by virtue of moving to a different spot, J.L. Davis's building, that's fine. But right now, we're talking about a violation that was occurring when the notice of violation was issued. And we want a ruling indicating that permit they're relying on for their vested rights is no more until the Supreme Court overrules the Environmental Court. Pretty straightforward.
Okay, thank you. DRB members, questions for Mr. Hall?
Nope.
All set.
Okay, thank you. Other members of the public that would like to address the board? Any raised hands, Hannah?
No.
Okay, last call for public comments. Okay, the appellant, would you like to have an opportunity to have a rebuttal of that?
Yeah, I don't disagree with Attorney Hall that it's pretty straightforward. Can you issue a second notice of violation? And again, I know that he was speculating on why we didn't seek some sort of stay, but again, there is no statute regarding staying the reversal of a permit. Very clearly, and with respect to the town attorney, 24 VSA 4449 talks about if an appeal is taken to the environmental division, the permit, not the reversal, the permit shall not take effect until after the environmental division rules in accordance with 10 VSA 8504. So again, that's addressing situations where the DRB issues a permit, neighbors perhaps appeal that permit. That permit will not take effect until the environmental division rules on whether to issue a stay, or until the expiration of 15 days, at which place the permit will take effect. This statute has no applicability here. So given that there is no statute on point, again, we're going to defer to town practice, which is that no additional enforcement action will take place until the appeal process has run its course. Again, it has not run its course. We have the final piece in 2 days from now. We'll get a decision presumably maybe 4 to 8 months from now. There's no urgency for acting on this second notice of violation. There's nothing occurring as far as we can tell between the parties. They didn't testify to anything. So again, given that there's no statute addressing this situation, we would defer to town practice and, proper discretion of this board.
Thank you. Okay, DRB members, any closing questions? All set? Okay. I'd like to thank everybody for the decorum tonight. And if I can get back to my time, that's right, over Donna's head. So I'm going to close this hearing at 7:47. Thank you, everybody, for coming.
Thank you.
Okay, the DRB is going to go into deliberative session. Okay, thank you, and welcome back to the Town of Williston Development and Review Board for Tuesday, October 22nd, 2024. It's 8:01. The DRB is out of deliberative session. Is there a motion for APP 25-01?
Yes, so I, Scott Riley, will make the following motion regarding APP 25-01. The appeal, under conditions of law, number one, the appellant, Dawn Pederzani, does not have a valid permit to operate a dog rescue home business. Under number two, conclusions of law, the zoning administrator did issue a notice of zoning violation dated July 24th, 2024, in conformance with the procedures of WDB Chapter 7. The motion that the board makes is as stated, as authorized by WDB 5.4.6. I, Scott Riley, move that the Williston Development Review Board, having reviewed the appeal of the administrator's decision, all of the accompanying materials, and having heard and duly considered the testimony presented at the public hearing of October 22, 2024, accept the findings of fact and conclusions of law for APP 25-01, an appeal of the issuance of a notice of zoning violation, and uphold the decision of the administrator to issue the notice of zoning violation.
Thank you, Scott. Is there a second?
I'll second it.
Dave Turner seconds. Any discussion? Hearing none. Yay or nay on the motion? Nate?
Yay?
Scott?
Yay.
Dave?
Yay.
The chair is a yay. 4 in favor, none opposed. Motion carries. Is there a motion to approve the October 8th meeting minutes?
I'll make a motion to approve the October 8th meeting minutes as written.
Thank you, Dave. Is there a second?
I'll second.
Thank you, Nate. Seconds. Any discussion? In favor, yay or nay? Nate?
Yay.
Scott?
Yay.
Dave?
Yay.
Chair is a yay as well. 4 in favor, none opposed. The meeting minutes are approved. Is there any other business to bring forth tonight? Is there a motion to adjourn?
I'll make the motion.
Is there a second?
Second.
Any discussion? All those in favor to adjourn the meeting indicate by saying yay.
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 Thank you all. Appreciate it.
All right.